Some people get there the wrong way. If you came to our presentation last year on this topic, you might see a few familiar names, but you might see some additional information, because some people are just the gifts that keep on giving. And the reality is, every year lawyers do stupid things, and that gives us a new set of materials that we've refreshed with some new stories for you. They want to do it, and we'll keep talking about it as long as they keep doing it. We've got some disclaimers here for you. One of them is to prevent us from getting sued for libel. The truth is a defense. We are going off of what's reported, so we're not taking a stake here on whether or not it's all true, even though many of these have gone to full adjudication. Just because you violate a disciplinary rule doesn't mean you're necessarily exposing yourself to civil liability or cause damage, but that doesn't mean you should go ahead and violate it. And you will note that we've deleted some names throughout this presentation. We've generally not done that for individuals. We've generally done it for prominent large firms that would be mad at us if we didn't. But actually, mostly because they are also, in many of these cases, the victims. And if they weren't the victims but the participant, we've gone ahead and left them in. In almost any large organization, there's a chance somebody gets off the rails. So that's our intro and disclaimer, and let's just jump right in, Jordan.
Very good. We're going to start out with one that might be a little against our interest as hourly billing lawyers. This is an overbilling case, and it's actually one where the redaction, perhaps the firm would prefer not to have it, because the firm caught the overbilling before any clients were harmed. It's a doc review case. An associate was tasked with some doc review, nothing all that interesting as far as those facts, but here's where the red flags started. The associate was given 425 documents to review and billed 277 hours to do it. Maybe a red flag by itself. That's about an hour and a half per document. Typically, we're budgeting 60 to 80 documents per hour. Perhaps you could have an extenuating circumstance where it's very complex documents, very long documents, but it already looks kind of strange. It gets a lot worse, and the way that it got found out is technology, because not only did the associate bill a lot of hours for not a lot of documents, he only opened about 5% of the documents that he claimed to have billed. So you've got 405 documents that he didn't even look at out of the 425 documents set. And of course, the firm confronted him, and he confessed what he had done. But this underscores the importance of bill review, which nobody really likes doing, whether as partners at a firm or as in-house counsel at a client. But it was very important here. Most of the time, your bill review isn't going to catch intentional misconduct like this. Most of the time, it's going to catch, an entry that should have been on a different client's file, which is important for confidentiality purposes, or perhaps something that should have been 0.6 and got coded as 6 hours. But here, it caught a much bigger problem. The associate was subject to a disciplinary proceeding under Rule 8.4C of the Illinois Rules of Professional Conduct, which forbids dishonesty, fraud, deceit, and misrepresentation. No surprise, the ABA and Texas both have very similar rules. And of course, you might guess, he also was fired from the law firm. So that takes us to our next case, which is Becky and some bankruptcy bonehead lawyer moves.
Yes. So our next bonehead comes out of the Neiman Marcus bankruptcy in 2020. Dan Kamensky earned 2 degrees from Georgetown. He worked as a big law bankruptcy lawyer for years, did stints at both Lehman Brothers and Paulson before he founded his own investment firm, Marble Ridge Capital. His resume is proof alone that not all of the boneheads we're going to talk about today are stupid. In fact, he's the opposite, and many of us would have been proud to call him a colleague and co-investor before all of this happened. And in fact, maybe someday in the future, because as you'll hear in a minute, he's arguably made it through this mess. But what brought Dan down started when Marble Ridge sought and obtained a seat on the Unsecured Creditors Committee. Kamensky, as Marble Ridge's representative on the committee, pressured Jeffries, a potential bidder, to refrain from making a higher bid for some of the assets that were at issue in the bankruptcy. And this is a major problem because the unsecured creditor committee members are supposed to be fiduciaries for all of the unsecured creditors. So he's not supposed to just be looking out for his own interests. According to the government, his goal was to make sure that Marble Ridge could buy the disputed assets for a lower price. But Jeffries had every right to bid on these assets for a higher price, and they were supposed to go to the highest bidder. He actually threatened to stop sending Marble Ridge's business to Jeffries if they moved forward with the bid and didn't back down. So they did initially take down their bid, but they were upfront with the committee about why, and they told the truth. And that's what brought Kamensky's down, because the committee's professionals and other members knew that his actions were improper. And actually, so did he. He tried to cover them up as they started to come to light, but a lot of his calls and chats had been recorded by Bloomberg Chat and by the Jeffries employees. He actually even told one of his contacts at Jeffries that he knew he would go to jail if his contact came out, but Jeffries had no interest in covering for him. And in fact, they later indicated interest in actually buying those disputed assets, and that sale was resolved through a settlement. Kamensky, on the other hand, ends up arrested, had to plead guilty to bankruptcy fraud, and watched his company be wound down. He was also sentenced to 6 months in prison, of which he served 2. But more recently, a New York court last year in July did grant his reinstatement, so he's officially back. This scenario violates a couple rules, statutes and rules. One is 18 U.S.C. Section 152, which is one of the bankruptcy fraud statutes, and it provides that a person who knowingly and fraudulently gives, offers, receives, or attempts to obtain any money, property, compensation, reward, advantage, or promise for acting or forbearing to act in any case under Title 11 shall be fined under this title, imprisoned not more than 5 years, or both. And then the second is Rule 8.04, which is a lawyer shall not commit a serious crime or other criminal acts that reflect adversely on that lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. Lastly, I think that this case study is actually a good, friendly reminder to not put anything in any chat programs, texts, emails that you don't want to come back to haunt you. I think people are a little bit more careless and flippant with what we do in that, but you shouldn't be, because all of those materials are frequently sought in discovery, just like all other documents and communications, so it's a good thing to keep in mind. With that, I think we go back to Robert.
Yeah, just pause before send. That's just a great rule for any kind of electronic communication. Just pause, rethink it before you send it. Get a second set of eyes if you need it. Okay, we talked about a gift that just keeps on giving, and Thomas Girardi is really just the epitome of that. This is a picture of him with his third wife, Erica Jane. He married her in 2000 when he was 60 and she was 28. He was a legendary trial lawyer in California. He was the first California attorney to get a more than $1 million verdict on a medical malpractice claim. He became nationally famous for his role in the $460 million settlement to 650 residents with PG&E that inspired the movie Erin Brockovich with Julia Roberts. He was elected in 2003 to the Trial Lawyers Hall of Fame. He built his own law firm, Girardi Keese, into a very well-known, very successful plaintiffs firm. They were sought worldwide for matters. They were involved in, for example, the Lion Air crash in Indonesia, and just a huge variety of cases, very high-profile cases. And yet today, that firm is insolvent. The legal liabilities and problems are just a myriad, and he is no longer married to wife number 3. So it goes down to a very basic issue that the district judge has said so well in that prior slide, but when you hold money for third parties, it's not yours to use for whatever you want. That's kind of the real basic here. His firm has filed bankruptcy. He's been sued for unjust enrichment, breach of contract, just all kinds of problems going on and on. So what did he do? Well, among other things, he took $750,000 from client cash to buy earrings for his Real Housewives of Beverly Hills wife. By the way, he was also a star in this show, made many appearances also. There's another trust that claims that he misappropriated over $101 million from client funds. He had many claims brought against him, over 100 at the state bar, and several suits. We'll talk about how he got out of them in a minute, but one hint might be this picture of the woman on the far right, a state judge, Tricia Bigelow, with whom he was having an affair while married to a Real Housewife. And she was a presiding justice downtown LA of one of the state courts of appeals, and he bought her an oceanfront condo in Santa Monica. And supposedly she didn't know that came from client funds. She just thought he was a big spender. But that's where 300,000 of it now has gone. He also has been criminally charged with embezzling another $15 million, pleaded not guilty. And he's been disbarred, ordered to pay restitution, and then, as any smart guy would, he suddenly has found that he's got mental health issues, particularly memory issues, and he's now in a facility that specializes treatment for that in order to not have to present at any of these trials. And that's pretty close to where things were. Some of that happened over the last year, but it's sort of a continuation about where things were a year ago, other than the criminal charge that was filed in February of this year. But, you know, a really good criminal just doesn't do things well by himself. More recently, the CFO of the firm, Christopher Kamen, turns out to have had his own side fraud scheme of about $10 million that he had raked off his boss. I mean, if his boss can rake off the money, then surely he can get his share. And he raked off a bunch of money, and then when this started falling apart, started liquidating his assets, wired it into foreign accounts in the Bahamas in 2021, fled to the Bahamas in September of 2022, somehow forgot to get on his return flight. But foolishly came back into the country in November, was arrested, detained. For some reason, they found he was a flight risk. But it still doesn't end there, okay? What we've learned recently, November, for example, 2 more attorneys have gotten into trouble because it appears that they were aware of problems and started covering. When clients would call to ask for their payment out of the funds that had been paid by the defendants already, they would make up stories about why the money hadn't been paid. And they tried to claim in their trial that they didn't know that Girardi was stealing client money, but they basically lied to other firms and to their own clients, because they were co-counsel also trying to get some of this money. The money had come into Girardi's firm, supposed to go out to co-counsel. Well, that was probably helpful because while you can stall clients, co-counsel want to get paid even more, and they have a little better sense of what's supposed to be going on. So it's just, as the court said, inexcusable for them to have been covering up the lack of funds in the firm and not being more transparent about it. When payments to a client are unreasonably delayed and you lie about why, reasonable measures need to be taken, which included, in this case, they should have contacted the court that was supervising the case and said, something's amiss. So one moral of that, separate and apart from the ethics rule about not dipping into client funds, is if an excuse doesn't make sense, whether it's your own, somebody in your firms, clients, don't hide behind those. Don't make bad excuses and become part of the problem. But that's not all. How did he get out of 100 ethics complaints filed against him by people that had been saying this for years? Well, corrupt the people who are supposed to oversee corruption in the bar. The State Bar of California has had to lay off many people that he had subverted, they'd paid off. He got, one guy who was terminated got payments and gifts of over $1 million from Girardi. And his wife also got those gifts while he was employed at the state bar. And the guy never disclosed it, and he was involved in overseeing some of these cases. A lot of other people got gifts. Relatives of people at the bar would get hired at nice salaries at the Girardi firm. Staff in the Office of Chief Trial Counsel got involved in matters that should have been assigned to other pieces of the bar. Just endless conflicts of interest. One of the tainted people actually ghost wrote a lot of the decisions about the ethical issues. Just all kinds of crazy stuff that went on. And affirmatively, he affirmatively used the state bar to discourage people from making complaints when they would contact the bar. That's how deep he had gone into that. So during 16 months of investigation and a ton of documents and witnesses, the short version is that the State Bar of California itself was pretty useless in overseeing this problem because they were in on the grift. That, I guess, oh no, there's one more. Keith Griffin and David Lyra were subordinate lawyers there. And the point is, even when your supervising lawyer makes judgment calls about issues, and especially ethical issues, the subordinate lawyer is still bound by the ethical rules, including obligations not to participate in a fraud and to report things. It's easy to remember exceptions about supervisory lawyers versus subordinate lawyers, but we're all equally bound by the same ethical rules. And it's not a pass to say it was my boss doing it, and they made the call, and I just went with it. And so subordinate lawyers have been dragged in, and we have the same disciplinary rules here in Texas on that. There's so much more on Girardi. If you really want to write a book, maybe he's got enough memory, you can buy the script from him and do a made-for-TV series. I mean, there's just a lot of meat there. Think about that. 3 wives, mega millions of frauds, all kinds of great stuff. Let's go to another lawyer who's really famous. We all want to practice before the Supreme Court. When we were in law school, we thought that was the peak. And we decided to go back to an oldie but goodie, Mr. James O'Hagan, a classic bonehead who has been memorialized in Supreme Court jurisprudence for his behavior. This is one of the seminal insider trading cases. We've talked in the past about the Apple lawyer that was trading when he was in charge of closing the trading window, and he would trade during closed windows on earnings information before it was released. I mean, that's a classic case, but I've got to say, he worked for Apple, but that's nowhere as close as making it to the Supreme Court. So, back a long time ago, UK company wanted to make a bid, a hostile bid for Pillsbury. And so they hired a firm that had good local connections for that transaction. We're going to skip the fact that that firm had a conflict issue, which later caused them to withdraw from the representation. But something pretty simple happened. Over lunch, O'Hagan heard some of his colleagues talking about this transaction, and based on that, decided to go buy stock and buy options in the target company until he became the largest individual stockholder of the target company. Now, one bonehead issue here is, if you're going to do something wrong, don't call attention to yourself. But that's not the moral we're trying to get through here. The moral here is don't do something wrong. But if you're going to do something wrong, don't be dumb. I mean, we expect the bar to set higher standards. Come on. So he became the largest single holder. This deal was done as a tender offer. And even though he didn't work on it, he did all this. As I said, the firm eventually withdrew from the representation before the tender offer launched. But when the deal launched, he made a lot of money. And he got caught up in a criminal indictment for 17 counts of securities fraud. Why would he do this besides greed? Well, usually the answer when somebody is motivated by greed is more greed. He had been stealing client funds and needed to repay them. Okay? And so this looked like a way, so what a great motive, right? I'm just returning money to those people. He had borrowed from the funds. He was convicted on all charges, sentenced to 41 months in prison. It went all the way up to the Supreme Court, not on an ethics issue, of which there was plenty, but simply because this is one of the seminal insider trading cases. At the time, there was still disagreement and a 4-4 split on the Supreme Court about whether the so-called misappropriation theory of insider trading liability was valid. And there was also a challenge to a rule that the SEC had adopted in the Chiarella case, where a Pandic employee had deciphered takeover documents and traded ahead of tenders. And the SEC, the court in Chiarella said mere possession of material non-public information is not by itself sufficient to constitute an insider trading claim. You've got to breach a duty. But the SEC said, okay, we're going to go adopt a rule under the tender offer rules that if you trade in advance of a tender offer, regardless of how you know about it and whether you have a duty, that's a violation of the tender offer rules. So that's what he was appealing. He was appealing, saying there's got to be a duty to the other stockholders that I breach, not just to my firm. And this tender offer rule is invalid because it doesn't require a breach of a duty. And Justice Ginsburg, writing for the majority, said wrong on both counts. And that's why we all remember O'Hagan. He cemented the misappropriation rule in Supreme Court jurisprudence, and he had the case that upheld the SEC's rule. So now we're in the odd case, sort of outside of ethics, that if you trade in advance of a tender offer, whether or not you have a duty to somebody, but you know about the tender coming, you're liable. If you trade in advance of a merger, they still have to prove breach of duty. It's one of the real oddities of insider trading law. The good news is most all of you have signed confidentiality agreements. You use any information about anybody that you learned during the course of your employment to trade on that. The SEC will argue that you've breached your duty of confidentiality to your employer and you violated the misappropriation theory. And as a lawyer, they don't even have to go there. You have a duty of confidentiality to your clients.
Right. Next case involves a Houston company, battery firm called Microvast. And it illustrates a lot of different problems for lawyers and ethics. Number one is that this in-house general counsel had sued his employer. And what happened was he alleged that he had orally been offered some equity compensation and that the company had rescinded that improperly. That by itself raises an ethical issue because under Rule 1.08, a lawyer transacting with a client owes additional duties, including to give the client a reasonable opportunity to seek independent advice and then to get the client's written consent. So the whole idea of an oral grant of equity raises an ethical issue. But that didn't stop this general counsel. He sued the company. There's another problem, not an ethical one, but a practical one, and that is that typically when a lawyer sues a client, it turns out badly. It's very often a bad idea, regardless of who is in the right and who is in the wrong. And that's true for fee disputes, it's true for other disputes, and it was true here. Because Microvast counterclaimed against this lawyer, and in the course of that learned that he had been improperly recording conversations at the company, and that he had fraudulently, in breach of his fiduciary duty, failed to return a laptop. So the jury did not have a lot of sympathy for Mr. Smith, the general counsel. He did not get his equity, and he did get found liable for breach of fiduciary duty. Interestingly, he did not get tagged with a large damage award. The jury actually rejected that. What they did is they made him return the laptop. But you still have the problem of a public decision in PR and Texas law book articles talking about how you breached your fiduciary duty. So even if there's not a big damage award, there's still a problem for this attorney. That takes us to Becky.
Okay, so our next Bonehead lawyer is Lori Devaney, who found some interesting uses for her stolen client funds. This one's a little reminiscent of the Girardi case study that Robert discussed, but we thought that what she used her stolen funds on was perhaps even more interesting, which is saying a lot right out of the box.
Best ethics headline ever.
If you can go to the next slide. So Lori Devaney was sentenced to more than 8 years in prison for stealing more than $3.8 million from 135 clients between 2011 and 2019. She would basically steal her clients' identities, forge insurance checks, and then deposit the funds into her account. She'd then tell her clients that the compensation for their various injuries would eventually turn up in their accounts, but of course, it never did. According to the DOJ, many of her victims were particularly vulnerable due to serious brain and bodily injuries. So then she used this $3.8 million, and you can see a few of these items on the slide, but perhaps most interesting, $35,000 on taxidermy expenses, presumably from her big game trips. So we're talking about like really flaunting things here, like Robert was talking about earlier. $195,000 on her mortgage, $220,000 on cigars. I don't even know how many cigars that buys. That's definitely not good for her health, but neither is 8 years in prison. A combined $91,000 on a Cadillac and recreational vehicle expenses, $58,000 on pet boarding and vet expenses, and let's not forget $60,000 at a luxury nudist resort in Palm Springs.
Hey, on behalf of Disney, I want to object to the association of Scrooge McDuck with her. Yeah. One, I've read a lot of Disney Duck comic books, and I don't remember him ever going to a nudist colony.
Is always appropriately dressed.
Yes, although there is a question about his and Uncle Donald's clothing. And second, he was cheap, which is different from dishonest.
It's true. So she actually pled guilty in June of 2022, and she was ordered to pay more than $4.5 million in restitution. If you can go to the next one. What's interesting on this one is that because the state bar client security fund was forced to make partial restitution payments to some of her clients, the bar itself actually lost $1.2 million. And so then that was one of the largest losses in the state bar's history. And as a result, they had to raise dues for all lawyers for 2 years to cover the cost of these restitution payments. So basically, all the lawyers in the state are having to pay a little bit more because of this Bonehead lawyer's bad acts. So don't do any of that, including the cigars.
You know, the great thing about Girardi is while he was stealing from his clients, he did not buy malpractice insurance coverage, so it did not affect your premium.
And with that, we'll go to Jordan with another truly interesting character.
One of my favorites, Scott Wollis. Scott Wollis, you're looking at 6 pictures with 6 different names, which is one problem. He was at one time a practicing attorney in New York under his given name of Scott Wollis. In about 1995, he got accused of overbilling. He never showed up for his disbarment proceeding, and instead he went on the run. And he stayed on the run for about 20 years. And that was a fairly successful run. He left New York, moved around, ended up in Florida as a fairly successful securities dealer. But he couldn't stay clean there either. So he then ended up in Massachusetts, where he worked as a bartender, and later as a real estate agent. And he was fairly successful at that too. But that's where things started unraveling. So he goes to Massachusetts, and he's practicing in this real estate firm, and he's using the name Eugene Grathwohl. Well, Mr. Grathwohl was a real person, and he was somebody who had dated Mr. Wollis's ex-wife. He was a plumber. And so he's practicing real estate up there in Massachusetts under this name. But he's still in contact with the ex-wife. The ex-wife lives in Delray Beach, but he's got a girlfriend in Massachusetts. So he goes down to Delray Beach, and he's trying to help his ex-wife get to the retirement funds that he had left behind at the law firm. But of course, he doesn't exist anymore. So he's doing this all silently. The girlfriend in Boston hears him in Delray Beach and realizes where he is, and he denies it. That's where everything just goes sideways, and he ends up getting caught with the assistance of his girlfriend and the denials of his ex-wife. So he gets 81 months in prison. He actually just got out this January, so he is on supervised release these days. Could not figure out where he is. The Bureau of Prisons does not tell you that. But the ex-wife never did get the retirement money because the government took it is using it for restitution to the victims of his various schemes. Those schemes started way back when he was at his law firm. Arguably didn't involve the firm, but one of the things he was doing was selling Scotch whiskey out of the law firm's offices. So he was, 20 years of this, and he is now famous. DOJ press releases are being done about his case. Takes us to the next one, a doc in the box.
Okay. We call this one the pill mill case because our next bonehead sadly took advantage of people who were seeking pain medication. Louisiana lawyer and doctor Joseph Double Threat Pasterik worked for Global Pain Management, or Global, as a prescribing physician. Global is allegedly a pill mill, which is a facility that illegally prescribes painkillers. So through that, he was allegedly distributing Schedule 2, 3, and 4 controlled substances through prescription practices that were outside the ordinary course of medical practice and for other than legitimate medical purposes. Specifically, according to his indictment, he prescribed oxycodone, methadone, Xanax, hydrocodone in exchange for cash and 3 simple office visits. So over a 4-year period between 2004 and 2008, he and another doctor saw between 40 and 80 patients each day, a day, and in total collected over $8.5 million in cash proceeds from patients during that period. After a 6-week jury trial in 2011, he was found guilty of a conspiracy to dispense Schedule 4 controlled substances, was sentenced to 1 year and a day in prison and 1 year of supervised release. And he did complete his supervised release in 2015. If you can go to the, okay, you're there. Important for this presentation, though, is that formal disciplinary charges were filed against Pasterik in February 2012 for violations of Rule 8.4. It's professional misconduct for a lawyer to violate or attempt to violate the rules of professional conduct, knowingly assist or induce another to do so, or do so through the acts of another, commit a criminal act, especially one that reflects adversely on the lawyer's honesty, trustworthiness, fitness as a lawyer, some of the things we've already discussed. And so the disciplinary committee recommended that he be permanently disbarred, permanently, and the board agreed. The Louisiana Supreme Court also agreed, noting that the baseline sanction for this matter was disbarment. It held that the board correctly found that the aggravating factors present in this case are a dishonest and selfish motive, a pattern of misconduct, multiple offenses, vulnerability of the victims, and illegal conduct. They discussed some of the guidelines for permanent disbarment, and while none of them were exactly on point, they found it was abundantly clear that permanent disbarment guidelines are merely illustrative, and they're not intended to bind the decision-making process, and that this conviction did arguably fall within the guideline because of the serious risk of bodily harm or death to which he was exposing his patients from this clearly dangerous prescription practice. So even though his acts weren't really legal in nature technically, and in fact completely illegal, he did suffer serious professional consequences as a result of this. And with that, I think we're back to Robert.
So we're going to stretch back a little in time to somebody who was really viewed as kind of a star and an example of activist lawyering on behalf of the underprivileged. This is a woman, Lynn Stewart, who actually started out as a librarian and teacher in Harlem. And she was so troubled by the situation she saw and the injustices that she felt that the families she was dealing with, the kids she was dealing with, that she went to law school, got a degree, and built her career around being an advocate for the underprivileged or the people that she viewed were excluded from a very materialistic society. And took on a lot of famous cases over the years, represented one of the Weather Underground people, represented one of the mafia crime bosses, Gambini, or was that my cousin Vinny? But she just really developed quite a profile, doing a lot of pro bono as well as paid representation. But one of her clients in particular was the one that got her into trouble. This is Sheikh Omar Abdel Rahman. He's better known as the blind Egyptian cleric. And after the first World Trade Center bombing in 1994, he started advocating that his followers should engage in similar actions with other landmark buildings, the UN, the various office buildings, all kinds of stuff. He advocated assassinating Damati, the senator then from New York. So very much in that, and with a heightened focus on anti-terrorism. Ultimately, he was arrested and brought to trial and convicted for his terrorist activities, and she was part of the defense team. He was then taken to a place some of you might have driven near. It's the Max Security Prison, which is just south of the road from Pueblo, Colorado to Canyon City, Colorado, just south of a town called Florence. That's where the Unabomber is. That's where the blind sheikh is, a bunch of other people. In order to visit her client there, she had to agree to some administrative matters that anybody going in there has to agree to. And one of them is that you cannot communicate messages from a prisoner in that facility to anyone on the outside. Okay? You can talk to them about what you need for their defense and their appeals, but you cannot be a conduit for messages. This is max security stuff, and she agreed to that. She signed that, did all that. She'd go to the Supermax there and meet with him. And what the government alleged is that she became a conduit for messages from him to his followers, and that those messages were part of instructions for terrorist activities in and outside, particularly in Egypt, outside the country. And she denies it, but the government presented tape that she didn't know was done that shows her sitting there while her alleged co-counsel, who was actually one of his close cohorts, colleagues, whatever you call a co-terrorist, was sitting there having an open conversation, and she'd say things like, "I'm a good actor, aren't I?" And so it's on that basis that she ultimately got convicted for 28 months in prison, but on appeal of that, actually the court remanded to the lower court to consider a higher sentence because it believed she'd also committed perjury during the proceedings. And so she was on bail pending appeal, but then resentenced 4 years later to 10 years in prison, which she served just out here in Fort Worth. And she served that, started in 2009, but in December of 2013 was released because she'd come down with breast cancer and was given about 18 months to live. She in fact lived until March of 2017. Okay. Well, the New York bar has a rule that provides for disbarment upon conviction of a serious crime, and she was disbarred. Texas has a similar rule against committing crimes or engaging in other criminal acts that adversely reflect on you. But candidly, that's not the message that I want you to take away from here. In fact, really the question you should ask about all of these, and some of you probably have been, is what does this have to do with what I do? Right? It's easy to shake our heads and say, I can't believe they did that. I would never do such a thing. Well, I'm going to play pop psychologist for a minute and say, what was her problem? I think part of her problem is she came to identify too closely with her clients. She started as an advocate for them, rejecting the violent approach and believing that the legal remedies would help them avoid the more serious violence and get things improved. But she so closely identified with them over time that she lost that differentiation and crossed the line. Now, I mention that because each of us can easily do that and probably find ourselves doing that at times. We can get so caught up in our clients, our company's business, and what they're trying to accomplish and the good things we believe in that they're trying to do that we can lose perspective about what should be done to protect the client or not. Should this issue be self-reported or not? Should it be bumped up the chain or not? Is it a good idea or not? And sometimes you're going to be in a meeting where the business people are all just kind of rallying around an idea, and the group is just forming, and you are being pulled into that. In fact, you'll either feel the same emotion that draws you into that, or you'll feel the need to keep all of your clients happy. And that's when you need to just take a deep belly breath, right? That's the kind that calms you down and cuts off the adrenaline and makes you take a little perspective and say, is this really the right answer? Because you may need to be the adult in the room that has to, for a moment, disidentify with that aspect of what your client's doing and think about the longer-term best interests of the organization. And that's a hard thing to do. But I think that is your job, and that's where she messed up. Defending criminals or alleged criminals, fine. Defending the underprivileged, fine. Getting to where you are passing messages to facilitate violent acts against others or suggesting a cover-up of any kind, not fine. Losing perspective about what's a good decision and what's not fine. So just use her and some of these others. I'd go to some of the others and I'd say, you know what, if I've got a colleague that seems to be living above his or her means and seems reckless in other aspects of their lifestyle, maybe it's worth watching them a little more carefully because they may be reckless in their practice of law as well, or in their business practices as well. They're warning signs. They're not guarantees they're doing something, but there were warning signs about a lot of these people and how they were using money and how they had interpersonal relationships that they would discard freely for their own selfish ends that raised red flags that should have been followed up in their business, in their law practice.
Our next scenario is the lawyer for Alex Jones, who had run the InfoWars conspiracy webpage. And Mr. Jones was on trial for defamation arising out of some of the false things he had said about the Sandy Hook massacre. But we want to focus on the lawyer, and is the defense lawyer for Mr. Jones. And what Jones had said throughout discovery is that he had no text messages related to Sandy Hook. But right before the trial, the lawyer, who apparently had a complete image of Jones's phone, inadvertently sent it over to the other side. And that led to what Jones called a Perry Mason moment, where he basically just had to admit, yes, I had these documents, they weren't turned over. And this was not the only discovery failure. He had failed to respond to other types of discovery throughout the case. So from a legal ethics perspective, what a lot of people were tempted to do shortly after this story came out is start questioning, was the lawyer negligent? Does the lawyer have some kind of liability? And the important thing to focus on here is that a malpractice claim has a causation element. It's not just about whether the lawyer made an error. In a malpractice case, the client would have to prove that, but for the lawyer's negligence, the result would have been better. Here, that Mr. Jones wouldn't have been found liable for defamation. Very, very high bar. And so what a lot of commentators, including plaintiff's lawyers, came out and later said about this is, yeah, okay, maybe Jones might have some theoretical malpractice claim here, but it probably has no legs. And the reason why is because he could never prove causation. So as bad as we all may feel if we inadvertently send an email or inadvertently send a document that we shouldn't have, frequently, there is no damage, there is no causation, and that's likely the case here. Takes us to
Okay.
Robert.
So, again, we may feel a little remote from some of these others, so that's why this one's here. This is all the others, I couldn't do that, but this is one where you kind of stop and say, this could happen. I could see it happening. Big deals, stuff that you deal with, stuff that we deal with, there are lots of people involved, big teams, lots of documents, lots of deadlines, a rush to get things done, and mistakes and ethical issues can arise with that level of complexity when things are not delegated properly or things are not supervised properly once they're delegated. So here we've got a borrower's counsel closes a financing transaction at General Motors. General Motors, which by the way can never go bankrupt, so you can always work things out outside of bankruptcy, right? They filed a UCC termination statement to release the liens from the loans that were being paid off. But the UCC termination, although correct about the loans being paid off, also listed some loans that were not being paid off and terminated the UCC lien in connection with that, and nobody caught it. And in theory, there are many layers of review, but when GM did the impossible and went bankrupt the next year, the bankruptcy court treated those lenders as secured. Basically, the bankruptcy court ruled that that was an erroneous filing and it would be given no validity. And the Second Circuit reversed. Second Circuit said no. A UCC filing signed by the people for whom the lien is being released is valid, even though everybody missed it and everyone in retrospect admits it's a mistake. That is a valid release. You, former secured creditor, are now an unsecured creditor in GM's bankruptcy. Not to mention, this is at a time when the government put a whole bunch of people, even senior to the senior creditors, and that altered significantly their recovery that they would have gotten in bankruptcy. So how does that happen? Right, we know the ethical rule is you don't neglect a legal matter entrusted to you. You need to control workloads so that matters can be handled with diligence and competence, right? That's the one every young associate wants to take into their supervising lawyer. You're not supposed to make me work this hard. And you can do that too, right? You can take that into the CEO or the CFO or the general counsel and say, no, I need a little less work so that I can be more diligent and competent. It's an ethical issue. If you've got direct supervisory authority, under Rule 101, you've got to make reasonable efforts to ensure that the supervised person's conduct is compatible with their professional obligations. Okay. I think most of us know how this can happen. It's a so-called minor document and a big deal. It's getting lost in the middle of a ton of things, the phone calls, the emails, the around-the-clock stuff. And if you're in a big team, there tends to be an assumption that somebody else has already read it carefully, and even that a second set of eyes have already read it. So the way you deal with this is you've got to have clear communication about not only who's putting it together, but who's reviewing it and whether they are the right person to be reviewing it. And you don't just sign things that come in. That's a hard one. But you don't just sign things that come in, which somebody did. The lawsuit here was brought against borrower's counsel by lender's counsel. Okay, perhaps because lender never sent it to their outside counsel to review. So it was only their own people that were at fault. But they had no cause of action against borrower's counsel because borrower's counsel is not their counsel. No privity of contract. So even though borrower filled it out wrong, lender had no recourse against it. Takeaway here, though, is think about the processes going on, especially when a lot of paper is flying fast, and make sure you really know that somebody is preparing and reviewing somebody else's work, that there's a good process there. And if you don't know that, find out or review it. And hope you would have caught it, because in a long list of loans being released, would we have caught it?
All right, next couple of scenarios we call ethics traps, and these are ones where they really just require a little bit of a double take. The first one deals with a missing Upjohn warning, and those are named for the Upjohn Supreme Court case from, I believe, the early 90s, where the court basically held that a corporation owns its privilege. It's not held by the executives, it's owned by the corporation. And it also implicates Ethical Rule 1.12, which says when you are representing a corporation or another entity, and there becomes some kind of ambiguity about whether you represent the entity or the constituents, the executives, it's the lawyer's duty to clear that up. And what happened here could happen in a lot of cases. There's a lawyer representing a company here, Motorola, and he's defending a deposition. And the questioning attorney asks the witness, "Are you represented by counsel today?" And the witness says, "Yes." "Is that this lawyer here, Mr. Irish?" "Yes." And the lawyer says nothing. Well, later there comes to be some adversity between the company, Motorola, and the witness. And the witness does what a lot of people might do in that situation and starts wondering, well, wait a minute, I thought this lawyer represented me. Now this lawyer wants to represent the company against me. How does that work? The court was fairly merciful to Irish, the lawyer, when he was sought to be disqualified, and really only put a constraint on him that he couldn't take depositions of this employee, former employee, on an adverse basis or represent the company against the employee directly. There are other situations where the lawyer might have been disqualified entirely. And the takeaway from this situation is, as uncomfortable as it may be, if there's ever a question about who outside counsel is representing or who the in-house counsel is representing, it's always the lawyer's job to clarify that at the outset. And it protects the company, but it also protects the employees who may be under some misunderstanding about who the lawyer is actually working for.
Our next scenario, the accidental joint defense lawyer, highlights some issues we wanted to discuss surrounding the joint defense agreements. As you can see from the slide, two lawyers decided to change firms, and they went ahead and obtained conflict waivers from the client who had actually hired them, which was one defendant in a lawsuit relating to the change in firms. But then the lawyer's new firm, which is a major law firm, wanted to represent the plaintiffs in that same lawsuit. So the other defendants in the lawsuit objected, arguing that a joint defense agreement they had had in the case meant that those two lawyers had to get conflict waivers from all of the defendants. Thus, the issue arose, was the conflicts waiver from the paying clients sufficient? And the district court judge said no, it was not. He said that the joint defense agreement created an implied attorney-client relationship between those two lawyers and all of the other defendants, so conflicts waivers should have been obtained from all of the defendants in that action. And he therefore barred the new law firm from representing the plaintiffs, which would have been a major representation for them. And so this implicates Rule 1.09, which governs conflicts of interest involving former clients and prohibits lawyers from, without prior consent, representing a person in a manner adverse to a former client if the two matters are the same or substantially related. Here, obviously, it was the same matter. And 1.09b, which then imputes those conflicts to all members of a successor law firm. This also highlights, again, the importance of making it clear who you're representing, like Jordan said a minute ago, and that whenever you have a joint defense agreement, you need to really be thoughtful for purposes of conflicts waivers.
Go straight to the calendar.
Yeah. The one thing I'll mention, we're going to kind of skip ahead because I know we really want to get to the cow manure case as a real highlight for us today, also for you. But we did have in here about Elizabeth Holmes, and the takeaway here, it's just about the potential hazards of joint representation. And again, it goes towards who you're representing. Here, Elizabeth Holmes had tried to argue that certain documents would be covered by a privilege because she was actually also being represented by the lawyer, and ultimately the court found that the lawyer was representing the company, not her personally. Every jurisdiction has different tests for this. So the point here is that you really need to be careful who you're representing and who holds the privilege.
Early in my career, I was told that things need to pass the smell test, and we're just going to go to something that failed the smell test on all kinds of levels. It's in the green energy space. The ethical rule here and legal issue is, in part, whether or not an attorney has immunity from certain kinds of suits, particularly from people on the other side. I mentioned in the GM-UCC case that the lenders did not have a claim against borrower's counsel. This is a case where, in the green energy space, a lawyer in California is facing litigation from an investor in a business venture based on the venture lawyer's actions, which are alleged to have aided and abetted a fraud. And this case is pending against John Jung, who's a big law partner. Now, these don't work in a lot of jurisdictions because of a very robust attorney immunity doctrine. But I think regardless, even though Texas has a very strong one of those, many of you are touching deals in many jurisdictions. You can't be confident that you will be assessed for civil liability only under Texas rules. Okay, that's one issue. The other is that you shouldn't be doing the things that might persuade a court to find an exception to attorney immunity. And the facts are simply this. Back in 2013, this guy was hired to help another guy, Brewer, put together a company that was going to take cow chips and turn that into energy, okay? So I'm supposed to make a potato chip joke here, but I refuse. The basic notion is that you go get farmers to sell you their cow manure, and you put it in these big distilling bins, and you use anaerobic processes to generate methane, which you then capture, and it becomes a source of green energy, okay? So the dairy cows that are destroying the environment become our saviors in this process. And the lawyer took a 2% equity stake in the company. We could spend a long time about ethical issues that come up with an equity stake in a client. Be very wary of them, make sure you fully disclose them. But basically, it turns out that the principal was alleged to have forged all kinds of documents related to this joint venture and arrangements with the dairy farmers and with the providers of the materials to provide the anaerobic process to get the methane and all that. And that whole thing blew apart, and he rescinded his interest. Okay? But then that same guy came back to the lawyer several years later, a changed man. And they created a new holding company, CH4 Green Energy, and they each and created a joint venture with another company. So now he's representing this guy and creating a joint venture with another company to do basically the same thing. And guess what? It turns out that once again, the leases, the acquisition of the manure, the engineering, the designs, this whole process turns out to be the product of forgery. And Dynastian, the other side, sued Young saying, this is the same fraud resurrected. Even though you are not my counsel, you had a duty to tell me that this is the same scheme that blew apart before, and you didn't. And then there were also the guy misappropriated funds and all kinds of things. So the short version is that the business failed. He got sued. He claimed attorney immunity. California court said, no, you're aiding and abetting a fraud, and that's an exception to attorney immunity, and so you're going to be charged here. Bad clients are not worth it. They're just not worth it. Fire them. fire them. If they stink, okay, if you're in the room when a stink bomb goes off, you stink too. That's the rule of law.
And with that, I think we're going to close in the interest of time.
Thank you.
Thank you.
Thank you.